Sorry. It's all right. This will be our ruling on the application for discharge made by the first accused person. Sorry, my computer is taking time. Yes, the state has closed its case, and the next stage would be the defense case. The first accused person applied for discharge at the close of the state case. He submitted the application in terms of Section 198, subsection 3 of the Criminal Procedure and Evidence Act, Chapter 907. The section reads as follows: if at the close of the state case, the court considers that there is no evidence that the accused committed the offense charged in the indictment, summons, charge, and any other offense of which he might be convicted thereon, it shall retain a verdict of not guilty. This is a provision which has been discussed a lot by judges, and as it's been explained in case law, the implications thereof. It is clear, but fair enough, the situation under which, where the court can find that there is no evidence, that situation arises in various circumstances. The Kachipare case cited by the applicant is the case often referred to and cited, and it has been helpful in giving effect. It says what it means is that there may be no evidence at all. The accused person may have not been linked at all. There may have been no evidence which links the accused person to the defense in the ordinary sense. If the accused person is not mentioned in evidence, then he does not have to go to his defense to explain why he should be acquitted, because there's just no evidence linking him with the offense. But there may be no evidence in circumstances where the witnesses were so poor in their testimony that you can't really act upon their evidence. At the close of the state case, you don't really consider credibility that much. You are saying on the face of it, if the witnesses are believed and they are on the face of it believable, and they have linked the accused to the offense, then the accused must go to the defense and perhaps give an explanation which may be reasonably possibly true. But there are cases where the witnesses are so bad that you can't really make any case out of the poor evidence. So in that case, there's no evidence. There are circumstances where, because a crime consists of various elements, in this case misrepresentation, which was alleged to have been made, which was intended to deceive, and which may have deceived the victim, resulting in actual or potential prejudice. If one of the elements which form part of the description of that crime has not been shown to exist by the state, then clearly there is no evidence of some part of that crime, and therefore the accused person is entitled to his acquittal. So those are the three scenarios. There may be no evidence completely, absolutely. Yeah, the accused is entitled to be acquitted. There's just no evidence. Or there may be no evidence of an ingredient of that crime. There's still no evidence. He must be acquitted. Or the witnesses are so poor that their testimonies do not qualify to be evidence upon which a court acting reasonably may convict. Then there's no evidence. Out of those scenarios, we have the issue of the credibility of the witness has not been the basis of this application. In fact, the accused person has been relying on the evidence of the witnesses to claim his acquittal. So the credibility of the witness is not really the reason for this application. So that one falls away. The accused person is not saying that nothing has been said about him. So the situation where the accused person has not been mentioned at all does not arise, it falls away. So the situation which the accused person relies on is the situation where an essential ingredient of that crime has not been shown, in the sense that as against him in person. He says, well, there may have been misrepresentation. We don't really want to delve into that. The state may have proved that. But it has not been proved that that misrepresentation was made by me, the first accused person. Mr. Counsel for the first accused person has said there's just no causal link, connection that has been established between conduct attributable to him and the crime in question. Mr. Jetero has submitted that there is no evidence that the first accused person was involved at all in the bidding process prior to the award of the tender. And that is the critical time at which this offense would have been committed. Everything else that happened thereafter may have happened, but is not evidence which points at any involvement by the accused person prior to the award from the bid. What he is essentially saying is that the first accused person did not influence the award of the bid. He may have participated later on, but that is neither here nor there. The bid had already been, the tender had already been awarded to him, to a company, and so his involvement is post the fact. And for that reason, he does not have to be put on his defense. If he is correct in that submission, then it means that we are obliged to acquit, because the law says we shall acquit. We have no discretion in the matter. It compels us to acquit if we concede and accept that submission by Mr. Jetero as well as his co-counsel. Co-counsel has also submitted, it's actually Mr. Jetero, who has said circumstances occurring after the award of the bid are irrelevant. They do not really point to the person behind the bid. The bid speaks for itself in the sense that it identifies the person who submitted it, And the state evidence said they know who submitted that. And that is the person, well, who perhaps should be expected to answer any questions relating to the bid that was submitted. So in essence, that is the basis of the application. And further, the accused persons sorry about that. The first accused person says the state dealt with a corporate entity. They have no reason to say that they dealt with an individual. The state opposed the application on the basis that this charge is very clear. The state case is that a tender was flighted, inviting bidders, and the state received a bid, which was submitted, and the bid was successful, and the contract, after a bid was successful, a contract was awarded pursuant to the award of the tender to the entity. And then a contract is sold, and then there are various issues relating to the performance of the contract. But the state says it was later discovered that that bid ought to have been awarded to the successful bidder because the bidder had submitted false documents. In the sense that it was not a registered company. If the state had known that the bidder is not a registered company, it would not have considered its bid as valid. It used falsified documents and certain documents which are not necessarily falsified, but which it used to support, purporting that it is registered, purporting that it is ZIMRA compliant, tax compliant, and purporting that it is NASA compliant. And investigations ensued for the purpose of identifying the true identity of that bidder. And the investigations linked the first accused person together with co-accused, but we are dealing with the first accused person with that bid. How? The state says because the first accused person signed the contract which followed the award of the bid, he must be the person behind that entity, which, according to the state, is not registered. And they say he also was involved in the operationalization of the tender. In other words, he went to the ministry according to the state, and he had discussions, and he took part in discussions representing that entity, which the state says is unregistered. And therefore, he is the natural person behind that. He is the one, therefore, who caused the state to deal with this entity which was registered, which was not registered. So for that reason, he has an explanation to give. He must then, because in the absence of an explanation, then he risks being convicted. That is, in fact, the test to be used. Is the accused person at risk of being convicted if he does not give an explanation? Were the facts presented, or are they on the face of it such that if the accused person does not give an explanation, then he risks being convicted? If the answer is yes, then he should go on his defense. It is common cause so far that the company and other business entities Act requires a trade name to be registered, and that the law had been gazetted as at the time that the tender was flighted. It is common cause that it was the intention of the state to deal with a registered company. And it is for that reason that with this bid, documents relating to the registration of a company, the CR6 of a company, the CR of a company, certificate of incorporation, were submitted. This was for the purposes of compliance with the requirements of the flighted tender, which was clear that the intention was not to deal with unregistered entity, but to deal with a registered entity. That is not, it appears to me, is common cause. If it is disputed, I'm not yet aware of it, but it was not really much subject of much contestation during the trial. It is also common cause that so far, the situation might change, I don't know, that Blackdeck livestock, Blackdeck livestock and poultry farming is not registered in terms of the Companies and Other Business Entities Act. So far, I have not had any serious contestation on that point. It is also not contested that it is the entity which entered into a contract with the state. It is also not yet contested that the bid which was produced in this court as exhibit shows that this entity, which is known as Black Livestock and Poultry Farming, participated in this bid, and that it associated itself with Blackdeck Private Limited. In other words, this entity submitted, at the top left corner, there is some logo, or it's part of the letterhead, I don't know, something which associates it with Blackdeck Private Limited. And then, for the purposes of showing that it is a registered entity, it submitted a certificate of incorporation of Blackdeck Private Limited. And for the purposes of showing of Sierra 14, it submitted a certificate of incorporation of private, which means that it purported that these documents relate to it. It also submitted a CR6 relating to Blackdeck Private Limited. It then submitted a tax compliance certificate, which on the face of it identifies it with Blackdeck Private Limited. But when one goes into the verification numbers and the other security features, a skywalk images, which means that the allegation by the state is that as a tax clearance issued to Skywalk Private Limited was then somehow used to give the impression that the entity which was submitting this bid was tax compliant. Then the same applies to the NASA certificate. A NASA compliant certificate was used in support of this bid to give the impression that the entity was tax compliant. But the witnesses told us that indeed those clearance certificates were issued, but not to Black Tech, which means that the bid itself was supported by fake documents. This far, that does not seem to be in dispute. And now, the only defense, the defense by the first accused person is that the state dealt with a corporate entity. It has no reason to then charge me, if at all, in my personal capacity. Well, what this does is to there are two things to it. The accused person is saying, he has given us a defense outline. A defense outline is given in terms of Section 66 of the Criminal Procedure and Evidence Act. It is an indication of the facts upon which the accused person is going to rely on his defense. It is not evidence at that stage. It only becomes evidence if at the state case, at the close of the state case, there is a prima facie case against him, and then he has to give evidence, an explanation which is reasonably possibly true. While the accused person accepts signing the contract, he's saying, I must not really give my own explanation why I was signing that contract. The state must accept that I signed it on my behalf as an employee, because directors are employees too, of a company. But he has not told us that. It is an indication of that is what he's going to say. And I get the thrust of the application to be that because a company is a person, when if at all it commits an offense, you deal with that company. This is the invocation of the corporate veil. This fictional person originates in common law, in Kanban law, which envisages limited liability. An investor who wants to do business and then deploys resources wants to do business without the risk that all his belongings, all his property will be at risk if the company flops or if the company misbehaves. So he's limiting his liability to his investment in the company and the assets that invest. So anybody who deals with that entity must then not look for the shareholders and so on. He must deal with that person, that fictional person who is a company, and satisfy his claim on the assets of that company, which means any shareholders contribution is at risk. But he says that's the extent to which you can go after me. Don't come to me as an individual. Deal with the company until you pierce the corporate veil. Until you show that there's reason to go behind the corporate veil, then you can't deal with me. Deal with the company that you dealt with. So, in Kanban law, you might have to demonstrate and satisfy the court that there's reason to go behind the corporate veil before you claim against an individual. But is it the same situation in criminal law? I don't think so. The parties have referred to Section 277 of the Criminal Law and Codification Act. Liability in criminal law is a bit different. Very well. 50. Okay. Okay, that's fine. Well, I'm not sure whether it's Mr. Jetero or his co-counsel who referred to Section 277 of the Criminal Law Codification and Reform Act. Section 277 of the Criminal Law Codification and Reform Act refers, the heading is criminal liability of corporations and associations and their members, employees, and agents. If one looks at it closely, what it actually does is to remove the corporate veil at first instance. What it does is that it recognizes that yes, a company may be charged, but it then goes on to say, under what circumstances can you impute criminal liability on a company? That is the purpose of Section 277. People, human beings, natural persons, let me use that word. That is the term we use in law. Natural persons may do certain things. They may be employed by a corporate entity. But that corporate entity is not liable for their criminal conduct. Something must be shown for the company to be charged for that. That is what the purpose of Section 277. If somebody is caught driving recklessly, he is guilty personally. If somebody steals is alleged to have stolen from somebody, it doesn't matter that they work for a company. The company is not liable at first. Something must be shown to make the company liable. That is the whole purpose of Section 277. Then it also goes on to say to allow persons to be charged in their personal capacity. And as I was saying, criminal liability is described in section, in part 2, section 9 of the Criminal Law Codification and Reform Act. It says, a person shall not be guilty or liable to be punished for a crime unless A, the crime is defined in the code. A person includes a company. So a person, whether natural or artificial or fictional as it were, will not be charged with any crime unless that crime is defined in the code. A person a person cannot be charged with an offense unless that person committed the crime or was a party to the commission of that crime which is defined in the code. So, if a director of a company commits a crime, he can be charged if he did that, because he's personally liable for his conduct. But the other person there, the fictional person, should only be charged if it was involved. So how does a company get involved in the commission of a crime? Section 277 answers that. I will not really dwell on that because I'm not dealing with a company. So what point are we driving at? If at this stage, is it really a defense which is available to the accused? Because it goes on to say, C, a person will not be guilty of a crime unless his or her liability is based on voluntary conduct. This does not arise. And then it says, if he that person engaged in a criminal conduct with the blameworthy state of mind. Then E, if his or her liability is based upon an unlawful conduct, that is upon if it is not excused by a complete defense. And it says defenses that are mentioned in Roman numerals X14, which I4, which is 14. That is chapter 14 of the Criminal Codification and Reform Act. So when you look at an offense, you then say, is the offense defined? Is the accused person alleged to have done any act or omission which constitute the offense? You are looking at the individual. You are not looking at any other person. You are looking at the individual. Then you are looking at whether that person acted voluntarily and whether he or she had the requisite state of mind. And then lastly, whether he is a defense which is recognized in our law. Not everything that an accused person says is recognized as a defense. Not every explanation amounts to a defense. Is it a defense that is recognized in Chapter 14 of the Criminal Law Codification and Reform Act? So where the accused person has been charged by the state in his personal capacity, and the state says he is the one who did it. If we look at Chapter 14, do we have a defense where the accused person succeeds and says, no, this is a common offense, it's not my offense? That is the issue. Then in terms of, but if that is not what they are saying, if they are saying we did not participate, we now come to the issue of how is the state seeking to prove his case. Is it seeking to prove his case through the evidence of an eyewitness, or is it seeking to prove its case through circumstantial evidence? The state has said it didn't use circumstantial evidence, but it has placed before us circumstances from which it is asking us to draw the inference that it is the accused person who submitted, who was behind this unregistered entity. I think that's all there is to it. He is therefore accountable. He must then give defense. He must say, if he's the one who was behind this company, this entity, was it registered? He must tell the court. And he must say on what basis he says so. Because what we have on the face of it is no registration. So the accused person must take the witness stand and say, okay, you signed for this entity. We say it was not registered. You say it was registered. Explain. And then we put questions to you. The state is saying this entity submitted documents that were fake. And you are the person whom we have identified with that entity because you signed a contract on his behalf. What can you say about these documents? And then we put questions to you. That is the clearance certificate. And if the accused person does not give an explanation, is he at risk of being convicted? If the answer is in the affirmative, then the accused person has to give an explanation which is reasonably possibly true. Circumstantial evidence works in a way that all lawyers now understand. From a set of circumstances, inferences can be drawn. But if several reasonable inferences can be drawn, then the accused person does not need to be convicted. But if the inference that the state seeks to draw from the facts that is presented before us is the only reasonable inference and exclude all other inferences which the accused person wants us to draw, which is that he was not personally involved, no personal liability, it was just, then he will be entitled to his acquittal. So clearly that, whether or not the explanation that he gives is reasonable and can safely be drawn from the circumstances, can only be arrived at after the accused person has given his estimate. I must say that a defense outline is essentially what it is. It is not evidence. It is an indication of what the defense is going to be. Then the state has the onus to deal with all issues arising from a defense outline. And the state has to do so on a prima facie basis. At this stage, it's just a case on the face of it. But if the accused person does not dispute a prima facie case, then it will crystallize into proof beyond reasonable doubt. So in the circumstances, we are satisfied that the state has established a prima facie case against the accused person. We will put him to his defense. That is the finding of the court. When can we proceed?
My dear colleagues were saying if the court diary is free, maybe Monday.
What do we have on Monday?
Monday and Wednesday.
You wanted Wednesday?
Monday and Wednesday.
Monday, what are we doing, Registrar? This is Monday. The Paul Guatiringa case, you can move that one.
It hasn't started,
So you can move it.
Yes.
Okay. Wednesday is okay for me.